This is the case of Meyer versus Uber Techologies, Incorporated, 868 Fed 3rd 66, Second Circuit 2017. Majority opinion by Chin, Circuit Judge. In 2014, plaintiff counter-defendant appellee Spencer Meyer downloaded onto his smartphone a software application offered by defendant counter-claimant appellant Uber Technologies, Inc. Uber, a technology company that operates, among other things, a ride-hailing service. Meyer then registered for an Uber account with his smartphone. After using the application approximately 10 times, Meyer brought this action on behalf of himself and other similarly situated Uber account holders against Uber's co-founder and former chief executive officer, defendant appellant Travis Kalanick, alleging that the Uber application allows third-party drivers to illegally fix prices. The district court joined Uber as a defendant and denied motions by Kalanick and Uber to compel arbitration. In doing so, the district court concluded that Meyer did not have reasonably conspicuous notice of and did not unambiguously manifest assent to Uber's terms of service when he registered. The district court held that Meyer, therefore, was not bound by the mandatory arbitration provision contained in the terms of service. For the reasons set forth below, we vacate and remand for further proceedings consistent with this opinion. Background. A. The facts. The facts are undisputed and are summarized as follows. Uber offers a software application for smartphones, the Uber app, that allows riders to request rides from third-party drivers. On October 18, 2014, Meyer registered for an Uber account with the Uber app on a Samsung Galaxy S5 phone running an Android operating system. After registering, Meyer took 10 rides with Uber drivers in New York, Connecticut, Washington, D.C., and Paris. In support of its motion to compel arbitration, Uber submitted screenshots of the two screens that a user registering in October 2014 with an Android-operated smartphone would have seen during the registration process. The first screen, at which the user arrives after downloading the application and clicking a button marked Register, is labeled Register and includes fields for the user to enter his or her name, email address, phone number, and a password, the registration screen. The registration screen also offers the user the option to register via a Google Plus or Facebook account. According to Uber's records, Meyer did not sign up using either Google Plus or Facebook and would have had to enter manually his personal information. After completing the information on the registration screen and clicking Next, the user advances to a second screen labeled Payment, the payment screen, on which the user can enter credit card details or elect to make payments using PayPal or Google Wallet, third-party payment services. According to Uber's records, Meyer entered his credit card information to pay for rides. To complete the process, the prospective user must click the button marked Register in the middle of the payment screen. Below the input fields and buttons on the payment screen is black text advising users that by creating an Uber account, you agree to the terms of service and privacy policy. See Addendum B. The capitalized phrase, which is bright blue and underlined, was a hyperlink that, when clicked, took the user to a third screen containing a button that, in turn, when clicked, would then display the current version of both Uber's terms of service and privacy policy. Meyer recalls entering his contact information and credit card details before registering, but does not recall seeing or following the hyperlink to the terms and conditions. He declares that he did not read the terms and conditions, including the arbitration provision. When Meyer registered for an account, the terms of service contained the following mandatory arbitration clause. Dispute resolution. You and company agree that any dispute, claim, or controversy arising out of or relating to this agreement or the breach, termination, enforcement, interpretation, or validity thereof, or the use of the service or application, collectively, disputes, will be settled by binding arbitration, except that each party retains the right to bring an individual action in small claims court and the right to seek injunctive or other equitable relief in a court of competent jurisdiction to prevent the actual or threatened infringement, misappropriation, or violation of a party's copyrights, trademarks, trade secrets, patents, or other intellectual property rights. You acknowledge and agree that you and company are each waiving the right to a trial by jury or to participate as a plaintiff or class user in any purported class action or representative proceeding. Further, unless both you and company otherwise agree in writing, the arbitrator may not consolidate more than one person's claims and may not otherwise otherwise preside over any form of any class or representative proceeding. If this specific paragraph is held unenforceable, then the entirety of this dispute resolution section will be deemed void, except as provided in the preceding sentence. This dispute resolution section will survive any termination of this agreement. The terms of service further provided that the American Arbitration Association, HUA, would hear any dispute and that the HE commercial arbitration rules would govern any arbitration proceeding. B. The District Court Proceedings. On December 16, 2015, Meyer, on behalf of a putative class of Uber riders, filed this action against Kalanick, alleging that the Uber app allows drivers to fix prices amongst themselves in violation of the Sherman Act, federal antitrust law, and the Donnelly Act, New York antitrust law. The district court denied the motions to arbitrate, concluding that Meyer did not have reasonably conspicuous notice of the terms of service and did not unambiguously manifest assent to the terms. Holding that no agreement had been formed, the district court did not reach Meyer's other defenses to arbitration, including whether defendants waived their right to arbitrate by actively participating in the litigation, and whether Kalanick was also entitled to enforce an arbitration agreement to which he was not a signatory. Defendants timely appealed the district court's July 29, 2016 order, denying the motions to compel arbitration. The district court stayed the underlying action pending appeal on the joint motion of defendants, taking into account, inter alia, the need for further appellate clarification of what constitutes adequate consent to so-called click wrap, browse wrap, and other such website agreements. Discussion. We consider first whether there is a valid agreement to arbitrate between Meyer and Uber, and then whether defendants have waived their right to enforce any such agreement to compel arbitration. I. The arbitration agreement. We review de novo the denial of a motion to compel arbitration, Spect v. Netscape Comscenes Corp., 306 F3D 1726, 2D Surrey 2002. The determination of whether parties have contractually bound themselves to arbitrate is a legal conclusion also subject to de novo review, ID. The factual findings upon which that conclusion is based, however, are reviewed for clear error, IDI. The parties dispute whether the district court's determinations regarding the lack of reasonably conspicuous notice or an unambiguous manifestation of assent are findings of fact subject to clear error review or conclusions of law subject to de novo review. Although determinations regarding mutual assent and reasonable notice usually involve questions of fact, the facts in this case are undisputed, and the district court determined as a matter of law that no reasonable fact finder could have found that the notice was reasonably conspicuous and the assent unambiguous. We therefore review the district court's conclusions de novo. A. Applicable law. 1. Procedural framework. Parties are not required to arbitrate unless they have agreed to do so. Thus, before an agreement to arbitrate can be enforced, the district court must first determine whether such agreement exists between the parties. This question is determined by state contract law. 2. State contract law. State law principles of contract formation govern the arbitrability question. To form a contract, there must be mutual manifestation of assent, whether by written or spoken word or by conduct. Spect. 306 F3D at 29. California law is clear, however, that an offeree, regardless of apparent manifestation of his consent, is not bound by inconspicuous contractual provisions of which he is unaware, contained in a document whose contractual nature is not obvious. Adriers at 30. Thus, California contract law measures assent by an objective standard that takes into account both what the offeree said, wrote, or did, and the transactional context in which the offeree verbalized or acted. At 30. Where there is no evidence that the offeree had actual notice of the terms of the agreement, the offeree will still be bound by the agreement if a reasonably prudent user would be on inquiry notice of the terms. Whether a reasonably prudent user would be on inquiry notice turns on the celerity and conspicuousness of arbitration terms. Spect 306 F3D at 30. In the context of web-based contracts, as discussed further below, clarity and conspicuousness are a function of the design and content of the relevant interface. Thus, only if the undisputed facts establish that there is reasonably conspicuous notice of the existence of contract terms and unambiguous manifestation of assent to those terms will we find that a contract has been formed. See Spect 306 F3D at 35. 3. Web-based contracts. While new commerce on the internet has exposed courts to many new situations, it has not fundamentally changed the principles of contract. Courts around the country have recognized that an electronic click can suffice to signify the acceptance of a contract, and that there is nothing automatically offensive about such agreements, as long as the layout and language of the site give the user reasonable notice that a click will manifest assent to an agreement. With these principles in mind, one way in which we have previously distinguished web-based contracts is the manner in which the user manifests assent, namely click wrap or click-through agreements, which require users to click an I agree box after being presented with a list of terms and conditions of use, or browse wrap agreements, which generally post terms and conditions on a website via a hyperlink at the bottom of the screen. Courts routinely uphold click wrap agreements for the principal reason that the user has affirmatively assented to the terms of agreement by clicking I agree. Browse wrap agreements, on the other hand, do not require the user to expressly assent. See Juliet M. Morangiello, Signals, Assent, and Internet Contracting, 57 Rutgers L., November 1307, 1318, 2005. Browse wrap encompasses all terms presented by a website that do not solicit an explicit manifestation of assent. Because no affirmative action is required by the website user to agree to the terms of a contract other than his or her use of the website, the determination of the validity of the browse wrap contract depends on whether the user has actual or constructive knowledge of a website's terms and conditions. Of course, there are infinite ways to design a website or smartphone application, and not all interfaces fit neatly into the click wrap or browse wrap categories. Some scroll wrap online agreements require the user to scroll through the terms before the user can indicate his or her assent by clicking I agree. Other sign-in wrap agreements notify the user of the existence of the website's terms of use, and instead of providing an I agree button, advise the user that he or she is agreeing to the terms of service when registering or signing up. In the interface at issue, in this case, a putative user is not required to assent explicitly to the contract terms. Instead, the user must click a button marked Register, underneath which the screen states, by creating an Uber account, you agree to the terms of service and privacy policy, with hyperlinks to the terms of service and privacy policy. Following our precedent, district courts considering similar agreements have found them valid where the existence of the terms was reasonably communicated to the user. Classification of web-based contracts alone, however, does not resolve the notice inquiry. See Juliet M. Morangiello and William L. Reynolds, From Lord Coke to Internet Privacy, the Past, Present, and Future of the Law of Electronic Contracting, 72-2 Mender L. Revern 452, 466, 2013. Whether terms are classified as click wrap says little about whether the offeree had notice of them. Insofar as it turns on the reasonableness of notice, the enforceability of a web-based agreement is clearly a fact-intensive inquiry. Nonetheless, on a motion to compel arbitration, we may determine that an agreement to arbitrate exists where the notice of the arbitration provision was reasonably conspicuous and manifestation of assent unambiguous as a matter of law. B. Application. Meyer attests that he was not on actual notice of the hyperlink to the terms of service or the arbitration provision itself, and defendants do not point to evidence from which a jury could infer otherwise. Accordingly, we must consider whether Meyer was on inquiry notice of the arbitration provision by virtue of the hyperlink to the terms of service on the payment screen, and thus manifested his assent to the agreement by clicking Register. As an initial matter, defendants argue that Meyer is precluded from arguing that no contract was formed by an allegation in his complaint that, to become an Uber account holder, an individual first must agree to Uber's terms and conditions. We disagree. First, as the district court observed, the pleading is not obviously a concession in that it makes no reference to Meyer's knowledge. Second, Meyer volunteered to amend his complaint on the record to delete the allegation at issue, an offer that was accepted by the district court. Third, regardless of the allegation or even the validity of Meyer's amendment, Meyer has attested that at the time he signed up for an Uber account, he was not aware of the existence of the terms of service or the arbitration clause contained therein. Construing the facts in Meyer's favor, we decline to hold that he agreed to arbitration based on the purported concession in his complaint. 1. Reasonably conspicuous notice. In considering the question of reasonable conspicuousness, precedent and basic principles of contract law instruct that we consider the perspective of a reasonably prudent smartphone user. The touchstone of the analysis is whether reasonable people in the position of the parties would have known about the terms and the conduct that would be required to assent to them. As of 2015, nearly two-thirds of American adults owned a smartphone, a figure that has almost doubled since 2011. Consumers use their smartphones for, among other things, following the news, shopping, social networking, online banking, researching health conditions, and taking classes. In a 2015 study, approximately 89% of smartphone users surveyed reported using the internet on their smartphones over the course of the week-long study period. A purchaser of a new smartphone has his or her choice of features, including operating systems, storage capacity, and screen size. Smartphone users engage in these activities through mobile applications or apps, like the Uber app. To begin using an app, the consumers need to locate and download the app, often from an application store. Many apps then require potential users to sign up for an account to access the app's services. Accordingly, when considering the perspective of a reasonable smartphone user, we need not presume that the user has never before encountered an app or entered into a contract using a smartphone. Moreover, a reasonably prudent smartphone user knows that text that is highlighted in blue and underlined is hyperlinked to another web page where additional information will be found. Turning to the interface at issue in this case, we conclude that the design of the screen and language used render the notice provided reasonable as a matter of California law. The payment screen is uncluttered, with only fields for the user to enter his or her credit card details, buttons to register for a user account or to connect the user's pre-existing PayPal account or Google Wallet to the Uber account, and the warning that by creating an Uber account, you agree to the terms of service and privacy policy. The text, including the hyperlinks to the terms and conditions and privacy policy, appears directly below the buttons for registration. The entire screen is visible at once, and the user does not need to scroll beyond what is immediately visible to find notice of the terms of service. Although the sentence is in a small font, the dark print contrasts with the bright white background, and the hyperlinks are in blue and underlined. This presentation differs sharply from the screen we considered in Nicosia, which contained, among other things, summaries of the user's purchase and delivery information, between 15 and 25 links, text in at least 4 font sizes and 6 colors, and several buttons and advertisements. Furthermore, the notice of the terms and conditions in Nicosia was not directly adjacent to the button intended to manifest assent to the terms, unlike the text and button at issue here. In addition to being spatially coupled with the mechanism for manifesting assent, i.e. the register button, the notice is temporally coupled, inasmuch as consumers are regularly and frequently confronted with non-negotiable contract terms, particularly when entering into transactions using the internet. The presentation of these terms at a place and time that the consumer will associate with the initial purchase or enrollment, or the use of, the goods or services from which the recipient benefits at least indicates to the consumer that he or she is taking such goods or employing such services, subject to additional terms and conditions that may one day affect him or her. Here, notice of the terms of service is provided simultaneously to enrollment, thereby connecting the contractual terms to the services to which they apply. We think that a reasonably prudent smartphone user would understand that the terms were connected to the creation of a user account. That the terms of service were available only by hyperlink does not preclude a determination of reasonable notice. Moreover, the language, "by creating an Uber account, you agree," is a clear prompt directing users to read the terms and conditions and signaling that their acceptance of the benefit of registration would be subject to contractual terms. As long as the hyperlink text was itself reasonably conspicuous, and we conclude that it was, a reasonably prudent smartphone user would have constructive notice of the terms. While it may be the case that many users will not bother reading the additional terms, that is the choice the user makes. The user is still on inquiry notice. Finally, we disagree with the district court's determination that the location of the arbitration clause within the terms and conditions was itself a barrier to reasonable notice. In Skouros, the Seventh Circuit determined that the defendant's website actively misled users by explicitly stating that a click on the button constituted assent for TransUnion to obtain access to the purchaser's personal information, without saying anything about contractual terms, and without any indication that the same click constituted acceptance of the service agreement. The website did not contain a hyperlink to the relevant agreement. Instead, it had a scroll box that contained the entirety of the agreement, only the first 3 lines of which were visible without scrolling, and it had no prompt for the reader to scroll for additional terms. Here, there is nothing misleading. Although the contract terms are lengthy and must be reached by a hyperlink, the instructions are clear and reasonably conspicuous. Once a user clicks through to the terms of service, the section heading Dispute Resolution and the sentence waiving the user's right to a jury trial on relevant claims are both bolded. Accordingly, we conclude that the Uber app provided reasonably conspicuous notice of the terms of service as a matter of California law and turned to the question of whether Meyer unambiguously manifested his assent to those terms. 2. Manifestation of assent. Although Meyer's assent to arbitration was not express, we are convinced that it was unambiguous in light of the objectively reasonable notice of the terms, as discussed in detail above. As we described above, there is ample evidence that a reasonable user would be on inquiry notice of the terms, and the spatial and temporal coupling of the terms with the registration button indicated to the consumer that he or she is employing such services subject to additional terms and conditions that may one day affect him or her. A reasonable user would know that by clicking the registration button, he was agreeing to the terms and conditions accessible via the hyperlink, whether he clicked on the hyperlink or not. The fact that clicking the register button had 2 functions, creation of a user account and assent to the terms of service, does not render Meyer's assent ambiguous. The registration process allowed Meyer to review the terms of service prior to registration, unlike web platforms that provide notice of contract terms only after the user manifested his or her assent. Furthermore, the text on the payment screen not only included a hyperlink to the terms of service, but expressly warned the user that by creating an Uber account, the user was agreeing to be bound by the linked terms. Although the warning text used the term createe instead of register as the button was marked, the physical proximity of the notice to the register button and the placement of the language in the registration flow make clear to the user that the linked terms pertain to the action the user is about to take. The transactional context of the parties' dealings reinforces our conclusion. Meyer located and downloaded the Uber app, signed up for an account, and entered his credit card information with the intention of entering into a forward-looking relationship with Uber. The registration process clearly contemplated some sort of continuing relationship between the putative user and Uber, one that would require some terms and conditions, and the payment screen provided clear notice that there were terms that governed that relationship. Accordingly, we conclude on the undisputed facts of this case that Meyer unambiguously manifested his assent to Uber's terms of service as a matter of California law. 3. Remand for trial. Finally, we see no need to remand this case for trial. Meyer offers no basis for his argument that we should remand for further fact-finding if we vacate the district court's ruling, other than his assertion that no circuit has previously compelled arbitration in similar circumstances. Although Meyer purports to challenge the evidentiary foundation for the registration screens, defendants have submitted a declaration from an Uber engineer regarding Meyer's registration for and use of the Uber app, as well as the registration process and terms of use in effect at the time of his registration. Accordingly, we conclude on this record as a matter of law that Meyer agreed to arbitrate his claims with Uber. 2. Waiver. Meyer argues in the alternative that defendants have waived their right to arbitrate by actively litigating the underlying lawsuit. Because Meyer's waiver argument is based on defendants' defense of this litigation in the district court, we conclude that is a question for the district court rather than an arbitrator. Accordingly, we remand the case to the district court to consider, in the first instance, whether defendants have waived their right to arbitrate. Conclusion. For the reasons set forth above, the order of the district court denying defendants' motions to compel arbitration is vacated, and the case is remanded to the district court to consider whether defendants have waived their rights to arbitration and for any further proceedings consistent with this opinion. Addendum A, Appellant's App 560. Addendum B, Appellee's Bar at 38.